I'm Professor Gary Lilienthal. After already publishing apparently accepted moral and legal arguments in support of a worldwide ban on torture in 2016, my colleagues asked me to argue the opposite case. Posner had already argued that states had no moral obligation to any compliance with international law. Further, Guzman had argued it was unlikely that international law could influence any decisions of fundamental state importance with any repeatable regularity. In respect of the international law touching the field of torture, Amnesty International observed that torture was routine by state officials in 141 countries. Having already published controversial arguments against a rules-based order of international law, this article's objective is to assess critically the force of any worldwide prohibition on torture. The right to freedom from torture is written in many human rights instruments. These instruments are said to protect all individuals from being intentionally subjected to severe physical or psychological distress by, or with the approval or acquiescence of, government agents acting for a specific purpose, including to inflict punishment or to obtain information. The United Nations Convention Against Torture provides the most precise and widely cited definition of torture under international law. One of the most universally recognized human rights, the prohibition on torture, according to DeWitt, has attained the status of a jus cogens, or peremptory norm of general international law. This is said to give rise to the obligation erga omnes to take action against those who torture. Erga omnes means towards all, or towards everyone, where rights and their correlated obligations are owed to all. A property right, for example, is an erga omnes entitlement, so that it is enforceable against any infringement of that right. An erga omnes right thus is cognate to a statutory right and distinguished from a contractual right which is enforceable only against the contracting party. In international law, the term erga omnes suggests obligations states owe to the entire global community. An erga omnes obligation exists because of an identifiable, universal, and undeniable interest in perpetuating critical rights and preventing their breach, with any state having the right to complain of the breach. Erga omnes norms include genocide and piracy. However, despite the prohibition of torture, apparently as a jus cogens peremptory norm, flowing erga omnes to all nations, it appears as paradoxical that a good proportion of the world's states, and probably many private organizations operating with either state control or acquiescence, are routinely conducting torture. Thus, the question arises as to whether or not there really is a worldwide prohibition of torture. In this article, the argument is framed to demonstrate that the very concept of jus cogens, peremptory norms, flowing erga omnes to all nations, is in practice unattainable. Synthesizing the facts and evidence with this thesis statement, there cannot be any such absolute and universal international law prohibition against torture. I have already strongly argued against the use of torture based on both normative ethics, law, and parliamentary administration. Now I propose to argue the opposite view, vigorously, so that those faced with the terrible decision of whether or not to use torture can be better informed. Alhoff deployed a philosophical methodology to argue in favor of torture. However, he used a completely different methodology to what we will use in this argument. His philosophical view was that if torture is permissible, given any of the dominant moral theories, and if one of those is correct, then torture is permissible simpliciter. Other arguments, especially legal arguments, have tended to be based on statutory interpretation, or on the famous ticking time bomb case. Therefore, I seek to remove the artifacts of research into positive law and its justifications. Since any legal proscription of torture is argued through a jus cogens as a threshold issue, I conduct a legally synchronic synthesis of the meaning of jus cogens through critical analysis of the term's meaning at various times, as independent of any prior judicial decisions. This kind of methodology would jettison solely positive law, but proceed with its synchronic legal analysis so as not to exclude relevant ideas merely for reasons of historicity. It would then try to reframe the facts into a new explanation of jus cogens. This can be applied practically to the popular view that torture is subject to a jus cogens ban under international law. The fallacy of jus cogens is that it is a text writer's municipal communis opinio, but held administratively to be based in customary international law. Any prohibition against torture appears to remain in municipal customary law form, breaches of which are proved as arguments based on fact, eliminating operation of any absolute peremptory governing norm.